Now, the Department of Justice says the delays of the National Register for Sex Offenders is a result of challenges within the prohibition of public information legislation. Let's bring in Busisiwe Seabe, a social justice activist, for more on this. Busi, good to have you, and thank you very much for your time. When the minister was making the announcement, she was sure that, look, end of February, she will release this. It will be made public. Now it seems the minister is saying, well, I didn't particularly read Section 52 of the Sexual Offences and Related Crimes Act properly, because anyone found to have disclosed the contents of this may actually be jailed or even fined up to 3 years. What do you make of this?
Good afternoon, Tabu. Thank you very much for having me. I think, the minister's utterances are a clear indication that we have a government that is not willing to put the safety of its citizens, at the forefront and as a priority. And what is fundamentally important for people to understand is that the National Register for Sexual Offenders is a vital tool that is designed to protect society by maintaining a database of individuals convicted of sexual offenses. So in essence, its purpose is to prevent offenses by ensuring that employers, particularly those in sectors involving vulnerable populations like children and the disabled, can screen potential employees, right? So however, when we look at the delayed release of this register, and the fact that it is due to concerns around, the glaring failure by the Department of Justice and Constitutional Development, we must be able to understand that to a large extent, it is not just a display of, bureaucratic inefficiency but it is also a blatant disregard to the duty that endangers, the safety of our communities, particularly women, children, and other vulnerable groups. And what is particularly essential for us to understand about this register is that a public register would act as a deterrent to potential offenders, right? Knowing that their crimes will follow them and limit their opportunities to reoffend, right? So it would empower communities to not only protect themselves and their loved ones, but most importantly, it would provide a sense of justice and security to survivors and their families, right? Who also deserve to live in a society that prioritizes the safety, their safety and their family's safety over the privacy of those who have violated them. So while the public register can enhance community safety, I do understand that there are, a lot of controversies around the release and making it public, as opposed to only making it available to employers or to, the SAPS or our, security sector of society. Because what we need to be able to understand is that, to a large extent, while the public register can enhance community safety, it can also, to a large extent, as critics like to argue, it can lead to vigilantism, stigmatization, and difficulties to rehabilitate offenders, doesn't allow them to reintegrate into society effectively. One thing that we can argue equally is that, the public has a right to safety, particularly for vulnerable groups like children, that outweighs that concern of privacy.
Now, the minister, of course, says now we need a review of the legislation to allow for the full disclosure of this information. What do you make of that? Is there any value that can be derived from that particular process, considering the fact that, well, most of these matters would have been ventilated in the courts already, so they are a matter of public record, that the register just makes it more accessible in one place where you are able to go and access this?
I think it's important for us to understand that, the releasing of this register is not just a moral imperative, but it is to a large extent also a legal obligation. So the privacy provisions that the minister is speaking about should not be used rather as a shield to protect sexual offenders at the expense of public safety. So while privacy is a constitutional right, it is not absolute, right? And the reason why I say this is when we look at Section 36 of the South African Constitution, it allows for the limitations of rights, including privacy, if it is reasonable and justifiable in an open and democratic society based on human dignity, on things like equality, and on freedom. So the harm caused by sexual offenses far outweighs the privacy concerns of convicted offenders, and the public's right to safety and the prevention of further crimes in this instance must take precedence. And this is something that the minister is very negligent of being aware of and also exercising. So the failure to release this register, it essentially sends a dangerous message. And the message is that the rights of sexual offenders are more important than the rights of their victims and potential future victims. Right? So this delay in releasing this register perpetuates a culture of impunity and leaves communities vulnerable to repeat offenders who could otherwise be identified and prevented from accessing positions of trust. So this also undermines the efforts of civil society organizations and activists who have long fought for the transparency and accountability in addressing gender-based violence and sexual offenses. But like earlier I mentioned, that this is not just a moral imperative, but a legal obligation. And that legal obligation is well confined within the Amendment Act of 2007 of the Sexual Offences and Related Matters.
My understanding is that now what the department is going to try and do is prioritize at least access to that information for institutions, for example, that would hire teachers, for an example, that have got to particularly be handling children and so on and so forth. So those particular organizations would have some kind of access to that information. At least that's what they're saying they will try and prioritize. Will that help?
It definitely won't help, right? A part of the reason why this register had to be made public and had to be accessible by members of, society in general is because, most sexual offenders can move freely within communities. They move freely within workplaces and even homes without anyone knowing their criminal history. So this lack of transparency puts vulnerable populations at risk and undermines the efforts to combat South Africa's epidemic of gender-based violence and sexual offences. It also erodes public trust in the justice system to a large extent, which already is under scrutiny for its handling of sexual violence cases. And to a large extent, everyone has a right to know the caliber of individuals that they are letting into their home, that they are letting into their work establishment, and that they are letting, to a large extent, move around freely in their community. What we must begin to ask is who exactly is on that register that the minister would want to rescind on a promise that she has made to make it visible. Are these family members of highly influential people that we're trying to protect? Are these people who are able to buy the silence of, to a large extent, our government? Because there is no real reason for them to keep this register private, to only give it to specific sectors of society when, to a large extent, it endangers even the homes within which people live in. So we need to be able to have transparency within our institutions and within government as well. And this is not something that is unique to South Africa. A public registry is something that you'll find in countries like the United States. But more importantly, I think a better example than the US would be in South Korea, where they do also equally have access to a public registry. But we must also remember that South Africa is a signatory to the international conventions, like the Convention on the Elimination of All Forms of Discrimination Against Women, and also the United Nations Convention on the Rights of Children, which requires proactive measures to prevent violence. And the release of this register is a proactive measure to prevent violence to a large extent. So the delays in releasing the register put South Africa not only in violation of these international obligations, but it also explicitly states that the state, to a large extent, does not respect, does not promote, does not protect, or fulfill the rights in the Bill of Rights that are included, under Section 12 of the Constitution. So by delaying the release of the register, in essence, the state is failing its own constitutional duty to protect citizens from violence and from harm.
Social justice activist Busisiwe Seabe, I appreciate your time. Thanks so much for coming on this afternoon.